All right, the world of oral arguments in our new times. This is being live streamed so the public can view it. And with that, Appellant's counsel may proceed.
Thank you, and good morning. Matthew Struble on behalf of the appellant, Andrea Pilecki. And before the court today is the issue of the terms of proposals for settlement that Federated National itself has described as novel, unique, and employed for the very first time ever in this case. And most importantly, the proposal for settlement and the upholding of that language is directly contrary to this court's opinion in Nunes. And in Nunes held quite clearly that two proposals for settlement that are served cannot be aggregated. As this court is well aware, in that case, there was a verdict for about $29,000. In order to uphold the proposal for settlement, it would have been required for two separate proposals for settlement, each in the amount of $20,000, to be added together and then compare that $40,000 amount to the verdict amount of $29,000. That's exactly what would be required to uphold Federated National's proposal for settlement in this case, where the verdict was for $15,000 and the proposal for settlement to Ms. Pilecki was for $5,000, inclusive of many other things. And the only way for that threshold requirement to have been met by the trial court was to add the $5,000 proposal for settlement to the separate $30,000 proposal for settlement to arrive at $35,000. And that is exactly what this court has held is improper. Federated National, in its answer brief, made no attempt to distinguish that whatsoever. In fact, the only comment that they made in response was to somehow indicate that somehow there's a difference because in this court's decision in Nunes, it was a plaintiff that had served the proposals for settlement. And they say somehow that's distinguishable because in this case, it was a defendant that served a proposal for settlement. Obviously, that is nonsense. It's based on the proposal for settlement statute. There is no way, there's no indication in the statute that somehow parties are to be treated differently. So on this case's authority in the Nunes opinion made very clear in line with other case law that you cannot aggregate proposals for settlement. So in this case, the proposal for settlement and the subsequent motions where the trial court enforced that must be reversed, because the only way that could be upheld if the trial court, if this court finds that the trial court properly aggregated those two separate amounts, and that is contrary to this court's decision. So based on that argument alone, we think it is clear that the trial court's orders upholding, awarding Federated National attorneys fees and costs must be reversed because that order can only be supported by aggregating settlement, which is improper. We believe that's the only issue that needs to be addressed because then everything else is resolved, but there are other independent reasons why the final judgment based on Federated National's attorney fees and their proposal for settlement should be reversed as well. Those include the fact that by the plain terms of the proposals for settlement.
Let me ask you this. Your opposition in their answer brief says that this case does not involve an aggregation of proposals for settlement. Rather, it was a set-off that the trial judge applied and that this court affirmed that, and as a result, your client did not get an affirmative judgment and this court affirmed that zero judgment. What's your response to that argument?
Yeah, so the response would be that the prior, the award or the decision affirming the final judgment was a PCA. So obviously we don't know the exact reasoning behind it, but Federated's argument, and the only way it could have been affirmed was that Federated argued that Mrs. Pilecki received the benefit of the $30,000. And that's the only reason why the set-off was applied. So if you take their own argument that they made in the prior appeal, their argument was based on the fact that, yes, the jury found they breached. Yes, the jury awarded Mrs. Pilecki an additional $15,000, but we paid $30,000 to another party. She received the benefit of that. So you would compare those amounts. And so, on the prior appeal, the court affirmed that. And now it's a separate issue of analyzing the proposals for settlement And if you take Federated National's very own argument in the prior appeal, they argue that Mrs. Pilecki received the benefit of the $30,000, so that you should compare the $30,000 to the $15,000 verdict. And that argument was apparently accepted by the court. And as Federated pointed out during the prior oral argument, what we're here for today is a separate independent issue now where you analyze the proposals for settlement. And as the language in this court explained, when you're applying the legal argument and interpretation as to a proposal for settlement, you cannot aggregate offers. So they were successful in arguing that Mrs. Pilecki could not recover further funds because they argued she received the benefit of $30,000. By virtue of that very argument, the proposal for settlement by $5,000 that they served could not possibly have reached the threshold amount. And the only way that could possibly occur would be if they are aggregated together. Obviously, aggregation is adding the amount of another proposal for settlement to $30,000 to the one that they served her, which was for only $5,000. So their prior argument very strongly supports our argument in this appeal. It's a separate and additional basis to reverse the final judgment on attorney's fees and costs. By the very terms of the proposal for settlement, it is ambiguous. If you look at, they serve two proposals for settlement simultaneously. You can see that they put Federated National, when they drafted it, they specifically said that the proposal for settlement, the $30,000 paid to Darren Pilecki, would not affect Andrea Pilecki's claim. And the release that they attached, they put that once again in bold. They said the $30,000.
Let me ask you about that argument. I read the transcript of the hearing twice and the memo in response twice at the lower court level. And I don't see, maybe I missed it, maybe you can help me out, but I don't see where that argument was made below. It was in certainly you emphasized in your reply brief, was mentioned a little bit in your initial brief, but I didn't see it below, because that does cause me concern that on the one hand, they say that this claim, will not factor in, if you would, and then sure enough, it does, because, but for Darren's acceptance of the proposal for settlement, they wouldn't be able to make this argument here today. So it seems to me to be an inaccurate statement in the proposal for settlement, but I'm trying to find where, if at all, is raised below.
Yep. So if I can, on rebuttal, I'll work on getting those exact citations.
Okay.
But I do have, and I will find the three different pages where we talked about in our initial brief. I believe there we have a citation to the memo where we talked about that as well. And as you can see from the judge's comment, he was specifically addressing that when we made that argument. And he said he had concerns about it. And he talked about the fact that Andrea Pilecki never signed off on it. She never agreed to it. And how could that possibly be okay? And he just went along with it because the prior judge had made that order. But if you look even in our the citations we have from the trial court, he's specifically addressing that argument and talking about the concerns that he had. And that was in response to our argument. But during the break, I'll locate some direct citations as to that. And that also goes along kind of with the third parallel argument that we have, is that Florida law is very clear that a proposal for settlement can't require that both parties mutually accept it. And that was discussed in detail and below as well as on our brief. And in this case, their proposal for settlement that they served as to Darren Pilecki, they put it in language there that it wouldn't set off or wouldn't affect Andrea Pilecki's claim. Then they had a contrary language that said that it would be set off against her claim. And they went on to ultimately argue that that language should be applied. As is clear, Andrea Pilecki never accepted nor had an opportunity to accept the proposal for settlement that was served to Darren. And she never had an opportunity to agree to the language of that. And the only way they can argue that, and the way they argued it was applied, was saying that what they served to Darren Pilecki had one sentence that said it would be applied to a set-off when it was $30,000 for all kinds of different damages. And Andrea Pilecki never had an opportunity to accept that language. And in order to find the proposals for settlement served in this case to be valid, this court would have to say that mutual acceptance is okay, and that the law is very contrary to that. And I think it's also kind of factually, if you look at the context of this case, the lawsuit was filed by Andrea Pilecki. It was the defendant that filed a motion to dismiss, made Darren Pilecki become a party in the lawsuit sometime later. And then when they served these two proposals for the settlement, they served one to Darren Pilecki, and he was offered $30,000 exclusive of attorney fees. At the same time, they served $5,000 to Andrea Pilecki, the one who initiated the lawsuit, for $5,000 inclusive of attorney's fees and costs as all other kinds of damages. I mean, we have some, other arguments related to how that they were improperly compared, but at the end of the day, we don't think those specific issues need to be reached because it's undisputed that the threshold requirements only met if they were aggregated, and in this case, they were aggregated, and that's clearly improper. So that's our primary argument on appeal. Okay. If no other questions, I'll take the time, and if I could, I'll use the time to find some citations.
All right, thank you.
Thank you.
All right, for the appellee.
Good morning. May it please the court. Karen Bellis of Kubicki Draper for the defendant below the appellee here, FedNat Insurance Company. FedNat's position is that it was correctly awarded attorney's fees following the final judgment in its favor and based on its enforceable and unambiguous offer to the only defendant who went to the only plaintiff who went to trial, Andrea Pilecki.
Well, let me ask you this.
Yes.
In the proposal for settlement, in one paragraph Roman numeral 3, it says, although Andrea Pilecki will be listed on the check, although Darren Pilecki will be listed on the check, the acceptance of this proposal and negotiation of the check will not affect the claim of Darren Pilecki. And then, of course, it says the exact same language the other way, except replacing Andrea with Darren. But the next paragraph, it says any amount paid will be a set-off. So, in this case, so Andrea has this proposal for settlement, and assuming, I think it's fair to say she would have known that Darren had gotten a proposal for settlement for $30,000 since they have the same attorney. If Darren accepts the claim, then she has to do much better on a verdict to avoid adverse effects from the proposal for settlement than if Darren rejected the claim. And this, these facts here kind of prove it. If Darren had rejected the claim, she wouldn't be paying any attorney's fees on a proposal for settlement. Now, Darren might be, but she wouldn't be. On the other hand, the fact that Darren accepted means all of a sudden she's looking at being hit with attorney's fees. So how could she, now I recognize there's a preservation issue, but how, setting that aside for a moment, how could she fully and independently evaluate the proposal for settlement without knowing whether Darren was going to accept the claim or not, or accept the proposal for settlement or not?
Your Honor, and if I may back up, I think what is, before I answer your question, I think that what has happened here is that there has been a spaghetti bowl created of intertwined issues. The set-off, the ordinary set-off that was addressed in the first appeal and affirmed. And that is why we resulted in this judgment in our favor. Compared with what we're dealing with here today, which goes to Your Honor's questions, the proposal for settlement to Andrea, the only defendant left at the time of trial, the test for whether or not this proposal for settlement is ambiguous is whether she could have made an independent, as Your Honor recognized, determination of what was going to happen if she accepted this proposal.
Well, she needs to do, if she accepts well, it still is affected by whether Darren accepts or rejects. Would you agree with that?
Not if she accepts this, no. What the test is whether
well,
on
if she rejects it, it makes a big difference whether Darren accepts or not. Would you agree with that?
If she rejects it, she gets a set-off, but not because of this offer, but because of common law set-off.
Right, but in evaluating the proposal for settlement, doesn't it make a difference whether Darren accepts his proposal for settlement or not?
No, because this offer tells her, Andrea,
Well, if Darren
exactly.
had rejected it, she wouldn't be in this situation. So it seems it did affect her.
But that's not the question. The question is whether under the case law, under the most recent case law, Branford, Nichols, all of the case law instructs that what has to occur is not whether someone else accepts, and that's not what's happening here, or whether someone else goes to trial. All she has to do, and the test for whether this proposal for settlement is valid, is whether at this moment, does she have the ability to make an independent decision of what happens if she accepts this offer. And if she accepts this offer, she gets $5,000.
Whether to accept or reject, aren't you entitled to consider all circumstances, your benefits and your risk? I mean, isn't that what evaluating a proposal for settlement means, is the opportunity to evaluate the benefits of accepting and the risk of rejecting?
The case law, and I'll quote from Branford, which quotes from Nichols. The reason the offer of judgment has to give the plaintiff or the party, it has to be reasonably clear enough to allow the plaintiff to make an informed decision whether to accept the proposal. And you can't nitpick to.
But if Darren accepts, her risk becomes much higher. If Darren rejects, her risk is lower. Isn't evaluating a proposal for settlement a matter of assessing the benefits and the risk? Well, let me ask you this. Would you agree that whether Darren accepts or rejects affects her risk factor?
It does, but it doesn't affect her ability to accept this offer of judgment and whether it is clear and ambiguous and serves as a valid proposal for fees.
Making a decision to accept or reject, obviously, would you agree it involves a determination of consideration of benefits and risk?
It does.
Okay.
It does.
So if your risk change depending on whether the other person accepts or rejects, how does that not affect your ability to make a fully informed decision on whether to accept or reject the proposal for settlement?
Because the question here is whether she could independently evaluate her case if she took the $5,000 and what would happen. And it is clear that
She has 30 days to make that decision, right?
Yes.
But if Darren accepts or rejects on day 6, which I believe is the case here, then she doesn't have 30 days, does she?
She had another 20 days to make a decision. And certainly if we follow the chain of thought that I disagree with, which is, and we have never, let me be clear, the defense has never asked, and the judge did not aggregate these two offers. Again, the trial judge simply.
I understand that.
Okay.
I understand. I'm talking about your sentence and your proposal for settlement that says that this will not affect the claim of the other party.
It says it will not affect.
That's something that you all inserted in the proposal for settlement. No one else did.
That is correct. But Andrea's proposal says it will not affect the claim of Darren Pilecki. That doesn't mean you look at Darren Pilecki's offer or his decision. It means that if she were to continue on, or rather to accept this proposal, Darren could either accept or continue on. Neither is required to do both. This lays out.
Let me ask hypothetical. So let's say you just made the $5,000 offer to Andrea and you never made a proposal for settlement to Darren. And then 2 days before and her 30 days is run, she never accepted it. 2 days before the trial, your side comes to Darren, I guess through his attorney, and says, we'll give you 50 grand to settle your claim. And he accepts it. And then you argue, then that should be set off against, I guess you then go to trial and you argue anything that should be set off against any verdict. And therefore, when Andrea gets a $15,000 verdict, the net is zero to her. It seems like if I'm following what you're saying if that happens, then Andrea had her 30 days to accept the $5 grand. She didn't. Now we simply look at the final judgment says you got 0. We offered you $5,000 6 months ago. You didn't take it. We're therefore entitled because there you go. I mean, that's kind of your argument, I think, that you're making here somewhat. I know there's a factor about Darren's offer, kind of the timing of Darren's offer and the form of his offer. But at the end of the day, the set off is something that's neither here nor there in the context of the proposal for settlement. It is something that was like either common law or somehow I wasn't on the panel in the first case, but is that basically what you're saying to us today?
Yes, Your Honor. And again, these two issues need to be separated out. The first appeal dealt with exactly what Your Honor has asked about, an issue raised by the plaintiff that an ordinary set off based on, it didn't matter what kind of settlement. In fact, it could have been a settlement from the mold remediation company. It could have been a settlement from anyone else, but that where you have two homeowners who have an indivisible right to recovery, if they receive monies, no matter where that money's come from, whether that was the $29,000 payment beforehand, whether that was the settlement here with Daryl by for $30,000, or as Your Honor described, a $50,000 settlement to Darren 2 days before trial. Our affirmative defenses had been amended to assert a set-off by collateral source, and that's what happened, and that is why we have a 0 judgment that gets compared to this clear and unambiguous offer. The offer,
following up on Judge Lambert's hypothetical, say the maximum damage claim was $50,000. So when you offered 5, you knew the plaintiff was seeking 50. So then you offer 50 5 days before trial, just so you can get attorney's fees against the 5. Does that sound like a proper use of the proposal for settlement?
I'm not sure I understand Your Honor's question.
Well, in other words, you create that situation where 5 days before trial, you pay one party the full amount of the claim, but then the other party is going to get hit with attorney's fees on a proposal for settlement if they dismiss it or if it goes to trial.
Here, the damages requested were $130,000 or $150,000.
I know, but let's say the maximum was 50. Well, let's say the maximum was 45.
I think what Your Honor is asking is about the validity of bookend offers. And this is and going back to the comment about this being unique and unusual, a lot of the case law, including a lot of the case law that invalidates joint proposals of settlement because they do not have an indivisible or independent right and ability to evaluate, contrary to these two separate proposals for settlement. This was unique because it's one of the first bookend type offers, but there is some case law, Hess. And I believe this addresses Your Honor's question. There are times, and it is a strategic decision by the party who is making the offer to decide, for whatever reasons, that maybe you want to get rid of one plaintiff, and the Hess case speaks to this. Maybe one is going to be more sympathetic in front of a jury. Maybe one has a stronger presence in front of the jury. So bookend offers are acceptable where you have an offer out there, and then the timing here was the exact same time, but a high offer and a low offer is acceptable.
But getting back to my hypothetical, the maximum damages are $50,000. The maximum damages are say $45,000. You make a proposal for settlement to Andrea for 5. She rejects it. A day before trial, you pay 50 to Darren. There's no way she can get a positive judgment. And then you can collect all your attorney's fees. But do you think that a court should uphold that type of strategy by a defendant?
Again, I don't think that's what happened here.
I know, but but in doing an opinion, we have to evaluate how someone might use proposals for settlement. So,
but also you have to look at the language as to whether or not it includes attorney's fees. And I believe Your Honor said that the $50,000 would include attorney's fees.
But if you do the 5 from okay, All right, go ahead.
I'm trying to explain here, this offer, and I'm not sure this answers your Honor's question, I apologize, but here, you have to look at the offer and release, and I'm not sure that is not what happened here, because Andrea had the ability to, this release and the conditions of her offer of judgment included attorney's fees and costs for her. So there wasn't any strategic, trying to lock anyone out here. She could have accepted the 5,000 or not.
No, she accepted the 5. It was actually 1/3 of the amount the jury determined was the appropriate damage.
But again, the bookend offers are acceptable, and who the offer was made to does not dictate whether this offer is valid and enforceable. You have to look solely to this offer, which tells Andrea exactly what happens. She accepts this, she releases bad faith, she releases her costs, she releases her attorney's fees, and Darren can go on. It doesn't affect the claim of Darren. If she accepts it and Darren continues, then paragraph Roman numeral 4 says her $5,000 will be set off against Darren's. But again,
So
that is a
based
common
on-
law set off condition.
Based on what the jury ultimately concluded, the 15,000, where we are now, her choice was to accept a proposal for settlement, which was 1/3 of what the value was, or to reject it, and when they paid Darren, get hit with attorney's fees.
No. She again went to trial and asked for $130,000. So she made
Right, but
the
I'm saying if the
choice.
damages were 15 when she was assessing it, you said, well, she could go ahead and accept it, but that's 1/3 of her claim. And then upon Darren accepting it, her risk for getting hit with attorney's fees became significantly higher. Those were her two choices.
Well,
Accept a claim accept a proposal for 1/3 of her damages, or increase her risk for getting hit with attorney's fees should Darren accept the $30,000 proposal.
again, we're combining the set-off issue with the proposal issue.
I'm talking about where she was sitting there when she got your proposal for settlement, knowing that Darren had gotten one for 30. So she's sitting there making her decision. She can accept for 1/3 her damages, or she can reject and face a much higher risk should Darren accept.
If I take your Honor's hypothetical respectfully, she was thinking this was crazy because this is 50th of the damages she was seeking. So she made a decision that her case was worth much more, but the amount of the offer isn't the issue. The amount of the offer would go to whether this is a good or a bad faith offer, which really hasn't been preserved here, wasn't preserved before entitlement was determined, and isn't what we're focusing on here. Again, this is the issues that are intertwined and need to be parsed out. The $5,000 would go to whether this is a good faith or a bad faith offer. Again, then you have to look at the full damages that were awarded, which was 29 paid before trial, and then the 30. And again, with the bookend offers, the determination strategically as to who to give a higher offer by the defense and try to go to, if someone went to trial against perhaps a plaintiff that would make a better case for the defendant. But that isn't the issue that we deal with when we look at whether this is a valid platform for fees, unless we're going to go to this was a bad faith offer because it was 5,000, which it wasn't. Because when you look at that issue, again, not preserved, not raised directly in this manner, and not what's been focused on here, you then have to look at the totality of the damages and the circumstances, which means FedNat was right in making a $5,000 offer to somebody because it had already paid 29, it had already paid 30, and 5 gets them above what it was even recovered. The plaintiff looked at this and thought this wasn't enough money because they were claiming 50 times more. Again, I think it was $150,000. Looking solely at this, those weren't her choices. Didn't need to look to anything else to know whether she thought the risk of going to trial was higher than what she would get if she walked away today. And again, that goes to the good faith nature of this offer. And this offer was made in good faith when you take a look at the totality of the damages sought and what the jury awarded. But this isn't an issue raised here. And plaintiff makes some mention in the briefing of it not being a good faith offer, but because going back to what was decided in the first appeal and the intertwined issues, that the offers were, the judge looked at aggregated offers, which he did not do. He looked solely at the four corners and said, she could have looked at this and said, I take $5,000, I get my attorney's fees and my costs are gone, or I go to trial and I risk fees. Again, under the Branford case and Nichols and valid bookend offers, all she gets to look at is this offer. And respectfully, I disagree that
But you would agree, would you not, that whether Darren accepts or not would increase her risk?
It means that she,
Yes or no? If Darren, would her risk be greater if Darren accepted than her risk would be if Darren rejected?
there's a risk she'll have a greater set off because there's already more money.
Well, and a
So
greater
yes.
risk she'll be hit with attorney's fees. Should
If
she
she
not?
doesn't get her 130, if she doesn't get over the 5,000,
If she had gotten, well, the jury came back 15. If Darren had rejected, she'd be fine in this
yes,
case.
yes, but that's the risk she chose to take, and this offer
Right,
was
but at the
valid.
time she had to evaluate, she may not have known if Darren was going to accept or not.
Well, again, you don't need to look to the other offers to determine if this is valid, but if you go back to the fact that there was one letter accepting and rejecting both offers from the same lawyer, and that was accepted by Darren within 7 days, she did have another 20-ish, 22, 23 days to decide what to do. And even in that extra 22 or 23 days, she decided she wanted to risk going to trial. This
Let
offer,
me see if Judge Lambert or Judge Wallace have any questions before I allow for rebuttal because you're over your time. Judge Lambert, Judge Wallace, any questions?
No, I'm fine. Thank you.
No.
All right, thank you.
thank you.
Okay, thank you. You have any citations? for
Yes,
me?
I'd like to. So all of these issues were briefed in writing multiple times in the trial court. So the first is plaintiff, we filed a motion it's at record 2561 to 2568. We filed another memorandum 2578 to 2591, another one 2609 and 2615, and another one 3095 to 310. And if you look at those memorandums, you will see where we not only made these exact arguments, we actually copy and pasted in the body of the motions the provisions that we alleged to be ambiguous. We addressed the fact that they said $30,000 doesn't affect the claim, but is contingent. We copy and pasted that in our motions. And we raised what are all legal issues in detail. The issue of mutual acceptance, as I think is clear, Andrea Pilecki only had increased risk if Darren Pilecki accepted her proposal for settlement. That is a proposal for settlement federated and drafted that requires mutual acceptance, which is invalid. Our memorandums address in detail the fact that you can't add the $30,000 to Andrea, to Mr. Pilecki, to Andrea
Yeah, but see,
Pilecki.
that's a different argument. That's, I don't think aggregation of proposals for settlement occurred here. So, and I know that argument was made below.
Yeah,
That's why I'm looking for.
Okay, yeah, so all those, as to the ambiguity, if you look at that motion, you will see we argued it was ambiguous because of that. We copy and pasted those language. It was addressed in page 2 of our brief, where we said when we cite the proposal for settlement, we cite that as being the language that's at issue. And if you look at page 15 of our initial brief, we cite that as one of the two arguments for it being ambiguous. Certainly, we didn't go to it in as much detail because it's a very simple argument. The fact that the terms are clear that they said in one proposal, in the proposal.
Now, would you agree that argument was not made at the hearing to the trial judge?
It was the judge was, as we know, in terms of preserving arguments, you preserve it by issuing written motions. All those motions were filed, sent to the court. You can't control what the court ends up focusing on. So yeah, he may not have addressed that specifically. He focused on, I think, a related issue when he had concerns about it. But in
I was
terms
just
of
responding, it
preservation,
says a simple argument, but I looked, that simple argument was never made at the actual hearing, so.
okay, yep, I think that, I do believe that is true, but if you look, at preservation, the best way to do it is filing written motions, which he did.
Okay.
They were all sent to the court. The court considered, obviously, we don't control what questions the judge asked at the hearing, but they were filed in great detail and written, which is the best way to preserve an argument for appeal, which is exactly what we did. And if you look at all those citations to memorandums, you'll see it. And because of those reasons, we think it's clear that the judgment for attorney's fees needs to be reversed.
All right, well, thank you both. It's an
Let me
interesting
ask just one.
Go ahead.
You heard my hypothetical to your opposing counsel.
If you could please get to me again, just because there was a lot in there, I was trying to find the citations.
Yeah, I mean, let's say Darren never got a proposal for settlement, but 3 days, I'll use the same number, 3 days before trial, they settle with Darren for 30 grand. And the trial judge decides that's a set off to whatever Andrea may get at trial. And you don't like that when that happens because it nets out 0 to Andrea and it goes up on appeal, and the panel in the first case said PCA. Okay. So why would then we not be simply looking at your 5 grand OJ was rejected and there was a net of 0, and therefore FedNat is entitled to fees under the statute and rule?
Because in your hypothetical, the Federated National settled directly with Darren Pilecki without serving a proposal for settlement, without referencing another proposal for settlement. And shortly before trial, what happened in this case was that Federated National served 2 proposals for settlement simultaneously.
Okay, I get all that. I mean, that's the lessening fun that I have in my job is I can make up hypotheticals that have nothing to do with the case. So my question is, the principle is you're saying, look at this, this is interrelated proposals for settlement, and it shouldn't be binding whatever Darren does on Andrea's decision. And I'm saying if there was never a proposal for settlement and there was simply they make a 30 grand offer as they're getting ready for trial and it's accepted, Darren's out of the case, it now gets set off against whatever Andrea may recover. Well, and I know Andrea might not like that, but that's the trial judge's ruling, and that's what happened. That gets affirmed on appeal. Wouldn't then this simply be you had a 5 grand OJ, your client decided, or proposal for settlement, excuse me, I'm 80 from myself. Your client did not accept it. They got a net of 0, and now here we are. Wouldn't that be?
Yeah, it would not, because in this case, the reason the issues occurred is because we're reviewing the terms of the proposal for settlement. And they serve 2 contingent on each other, which refer to each other. That's the clear ambiguity in your scenario. That wouldn't have been because he accepted a proposal for settlement that affected Andrea Pilecki's claim. It would have been because he offered a settlement. So she would have never received a $5,000 proposal for settlement when the other plaintiff received a different proposal for settlement, and that other plaintiff's proposal for settlement affected her proposal for settlement. So you would have never even had the issue of her receiving a proposal for settlement contingent on the other party receiving a proposal for settlement. And that's why the issue is here.
Okay, well, I'll accept your answer as basically, or I interpret your answer to mean that I know it's different. My facts are different than yours, but under my facts, you would lose. That's how I interpret your answer, unless you want to clarify your answer.
Yeah, no, because the reason why we win here is because it's 2 proposals for settlement we're looking at with her proposal for settlement.
Okay, I'll wave the big flag. I get that there's 2 different proposals for settlement, and that's why you think you should win here, because I'm saying under my hypothetical. I mean, Chief Judge Evander had lots of discussions with your opposing counsel about this, and I get all what he's saying. And I'm just saying, let me change the facts for you, which I did. And now that's what you're appealing, because there was just 1 proposal for settlement to your client that she did not accept, and she got a net judgment of 0 because there was a set off that was applied because her co-plaintiff settled and the trial judge allowed the set off.
Correct. Yeah. So a defendant is free to settle a case in that manner, and she wouldn't have received a proposal for settlement contingent on another proposal for settlement. And that's the issue.
Well, that Judge Lambert's hypothetical would, the check would be made out to both clients. Would your client then have a later opportunity to accept or reject, or would they be, could they accept the 30, say that fairly does it, we're dismissing, and if so, would your client have been hit with attorney's fees?
So if you're talking in terms of settlement, and what you're referring to is there's an actual.
I mean, following up on Judge Lambert's hypothetical,
Yeah.
I think it's a good one. So 30,000 is paid, is offered to Darren 3 days before trial,
Okay.
and the check would be made out to both. Can your client at that time say, okay, we're good, 30,000, or
Yeah,
or
if she
your
had an
client bid, would
opportunity,
your client still be subject to attorney's fees?
well, in that instance, you would have had an opportunity from your hypothetical to agree to it. What happened in this case is they set 2 unilateral proposals for settlement. Andrea
We both
We all
understand what happened in this case.
We get your position about what
Of course,
happened.
this issue may go away because I think the legislature has considered a statute where the proposals for settlement where there's identical interests are to be either mutually accepted or mutually rejected. So
Yeah, understood.
this
That
issue
mean
would
it
certainly
should be
that'd make my
aggregated.
job easier. I would appreciate that if they do
They
that.
should be aggregated then and mutually. Oh, then I wouldn't have had to keep writing Nunez over and over.
That was
I
good.
blame that all on Judge Wallace. He's on the panel.
I'm the nitpicky judge. Yeah.
You're the nit. You and Justice Lewis are.
all right, well, it is an interesting case. Thank you both for your arguments.